child's father's week that would have previously been her week, because that week on didn't happen. So that's a reasonable interpretation in this court's mind, certainly, and having seen it before, of these orders. Under either analysis, and again, I'm here to decide whether or not there's probable cause to believe that a crime was committed, not as to whether or not she has complied with the order, nor to necessarily give an interpretation of that order. That's where other proceedings.
Trooper, in the 4.5 years that you've worked for the state police, is this a common thing, common part of your duties?
I'm sorry, what do you mean? As in,
I guess is
are you
serving orders for child custody, is that a common part of your duties?
in my 4.5 years, this is the first time I've had to do it.
The only time you've ever had to do it is in this case.
Yes.
So it's unusual. And you indicated that you spoke, well, I guess let me circle back. You received the order from Detective Buxton, correct?
Yes.
And where did Detective Buxton get it from?
And he advised me that he received it from Mr. Johnson.
From Mr. Johnston.
Yeah.
So Detective Buxton didn't get it directly from the court either,
Unless he actually,
to your knowledge.
to my knowledge.
Okay. So you then told, as you indicated, you met with Ms. Lovely and you told her about the order, and she indicated that she had doubts about its authenticity, correct?
Yes.
And you testified already, but that she told you that a motion had to that effect had been denied, correct?
Yes.
Right. So she asked you to independently verify that that was accurate, and you agreed to do that.
Yes.
And you told her that you would do that.
Yes.
Okay. And then by the time you were able to do that was September 10th, correct?
To
To verify the document was authentic.
the 13th, she didn't.
February, excuse me, February, not September.
She requested on the 10th for me to verify the document, not on the 7th.
Okay, so you agreed to do it on the 10th,
Correct.
and then you verified it on the 13th.
Correct. 10th was Friday night. Courts were closed.
Right.
The 13th would have been the earliest. That was Monday morning.
So she had indicated, when did she indicate to you that she was concerned about the veracity of the document?
On the 10th.
She didn't tell you that on the 7th?
I do believe she probably did indicate it on the 7th.
Okay.
I don't recall.
Okay, so things she told you on the 7th, she certainly told you about the CPS investigation on the 7th.
Yes, she did.
Okay. Judge, if I could just have a moment.
You can.
Did you ever attempt to independently verify that that order had been entered prior to February 10th?
No.
You didn't look into Odyssey or any other system?
Yes, I did.
You did?
Yes.
Okay, what did you do?
It's not really a system I'm familiar with,
Mhm.
so I attempted to look through the online court system to see if any of that documentation, or through the family court system,
Mhm.
to see if that order had been posted within it, and I did not see it in it.
And when did you do that?
I don't recall which date I did that.
Would you agree that it was somewhere between the 7th and the 10th?
Yes.
So you were, between the 7th and the 10th, you looked and you weren't able to see that that order was entered either?
Correct.
Nothing further, Judge. Thank you.
Any redirect?
I just want to reiterate. Did she express some doubt over the veracity of it on 7th of February of the order that you presented to her?
Yes, she didn't think it was a good document.
Okay. And then she might have also expressed some doubt on it on the 10th.
Yes.
That caused you to follow up with the court on the 13th.
Yes.
Okay. Thank you. I don't have anything.
All right, thanks, Trooper.
Thank you.
Yes. Any additional witnesses?
I don't have any other witnesses, Your Honor.
Any witnesses for the defense?
No, thank you, Your Honor.
All right,
Your Honor, at this point in time, I motion to bind the defendant over on the charges contained within the information, the one count.
response.
Your Honor, I object. First of all, it seems to me that based on the testimony, this entirely occurred in South Lyon. So I'm not really sure that there's jurisdiction. This appears to have, the child was in Oakland County the entire time. So I think there may be a question as far as venue. However, on the facts of the case, the testimony is relatively clear from the trooper that he showed her this order on the 7th. She indicated to him that she didn't think it was accurate. They both, I think, he independently attempted to look in Odyssey, couldn't find the order. There was an order, a motion that was made and denied, which was testified to by Mr. Johnston. So at the very least, it makes it clear, I think, that there's confusion over what order would be entered or what order would be accurate if there was, this motion was already denied on one motion and then entered on another. Additionally, Your Honor, when the officer presents this to her and she indicates that she doesn't believe it's accurate, he agrees to look into it. Just a reasonable person would interpret that the officer is considering that possibility and is looking into it. If the officer is looking in to determine whether or not the document is accurate or true, it's reasonable for a person not to follow it until they're told that it is.
Or that they go and determine that themselves.
And she hasn't testified that she attempted to do that yet. However, need to prove that she attempted to do that, and it wouldn't have done any good because the officer already indicated that order was not in the system yet,
or that he couldn't find it.
But it does take time for those orders to appear. She couldn't independently verify it. By the 10th, that's now her parenting time. She hasn't received verification from the officer yet, who's indicated he's going to look into it. He does. She gets verification on the 13th, but that order does not change, and the court indicated that order does not change her parenting time. Now she's into her week. So the child stays with her until the 17th, and then the child would go back to the child's father on the 17th, according to the parenting time agreement. That's obviously changed by the February 14th order, but that's not really what we appear to be discussing here. The issue seems to be this time period from the 7th to the 10th. Because the order that issued on the 14th said she had until the 24th to return the child, and the child was taken by the father on the 16th. So we never got to the violation of that particular order. So based on all of that, Judge, based on what the officer told her and what the officer did and how it would imply to her the possibility that this order is potentially untrue or invalid, he couldn't independently verify it. He couldn't tell her that it was accurate until her parenting time had started. I would ask the court to dismiss the charges in their entirety. If nothing else, perhaps it's the basis of a show cause that could have been handled in family court, but as far as a parental kidnapping, I don't think it rises to the level to criminal conduct when the officer himself agrees to take on the task of verifying the veracity of the document.
I would ask the court, and I know the court's probably already aware of this, anything that our arguments are not evidence, but anything that Mr. Overwater argued was that what she did, there was no testimony to that. So let's just focus on the evidence that we have. Take or retain for more than 24 hours the child with the intent to detain and conceal the child from the child's other parent. What do we have? On the 6th, CPS says that Mr. Johnson testified, CPS indicates that child custody is to resume as normal. At the 7th, he's supposed to pick the kid up from school. The child does not go to school that day. That prompts Mr. Johnson to then turn his investigations both to the police as well as friend of the court. He did this order. He talks with the trooper. Trooper turns around, talks to mom. At that point in time, mom is on notice. She says, I'm not returning the child. I don't believe that's real. Fast forward to the 10th. He tells her, you have 24 hours to do this, or you could be looking at charges. She rolls those dice. She says, well, I'm throwing it. The 10th, nothing changes. Custody has not changed. Mr. Johnson testifies he has not received his kid, his child, in those intervening days. Trooper Pitzel goes back on the 10th, says, hey, what's the deal with this order? She says, I don't believe it's real. I'm not giving the kid back. He verifies it on the 13th at her request, verifies that it was in fact real, she says, I'm still not going to return the child. It is what it is. 24 hours she had to return the child or comply with the custody agreement. That order was entered on the 7th. She was made aware of it on the 7th. There's no testimony to suggest that there was anything else that was going on, other than there was this order that she had to comply with, and she didn't comply with it between the 7th and the 10th. So for that, Your Honor, as the court knows, this is an order out of our circuit court that gives this court venue and jurisdiction. That's where the order arises out of. That's where the underlying custody agreement comes out of, this court, giving this court jurisdiction over this matter. Therefore, I would ask the court to bind the defendant over on the charges contained in the information.
I think there may be two bases for certainly venue and jurisdiction of this court. The one that's brought up by the prosecutor, so I can dispose of that. It's enforcing a Washtenaw County order. Also that the venue is stated on the complaint is Northfield Township. There's going to be the 1 mile, certainly, or any conduct that occurs within that. So the court does believe it has jurisdiction and the venue is proper here. As with respect to the elements of this offense and when it occurred, what a wonderful world we would have if defendants who were presented in order by a peace officer were able to say, I don't believe the order, and just not comply without doing their own checking, without doing their own, I guess, footwork on it. Certainly, officers may assist in that, but once presented with the order, it is the person who is subject to that order's obligation to follow it, check it, verify it, and make sure they're in compliance with it. This defendant didn't do that. She just said, I don't believe this order, and then left it to everybody else. What is also clear from the testimony is that the parental father knows that it's his time and he has that order. He follows all lawful means to obtain the order. The order gets served on the defendant. The defendant says she doesn't believe it. The trooper told her she had 24 hours to comply with the order. She didn't. The question then becomes, well, and that's going to be from the period really from the 8th, because of the 24-hour period, to the 10th, that she did not comply with the order. And that in and of itself constitutes that offense. I think it may be a question of fact for the jury as to what the February 17th order means in terms of it going back, because there are different interpretations. One interpretation of that order, on the face of that order, one interpretation is, if you've interfered with my custody, then I basically take your week. So I still do the off and on, but now the weeks are reversed. That's one way to interpret that order, because it's just week on, week off. The other way to interpret that order is we go back to the normal schedule. I don't know which way that order really reads on the face of it, but in either event, I mean, and that to me says that that's going to be a question of fact, because it may very well be that the defendant then interfered with what would become the child's father's week that would have previously been her week, because that week on didn't happen. So that's a reasonable interpretation in this court's mind, certainly, and having seen it before, of these orders. Under either analysis, and again, I'm here to decide whether or not there's probable cause to believe that a crime was committed. not as to whether or not she has complied with the order, nor to necessarily give an interpretation of that order. That's for other proceedings. Given all of that, the court does believe that the defendant has committed the offense of kidnapping, custodial interference, and that people have sustained their burden of showing that by probable cause, either, so that we're clear, either is to that period after being presented with the order and not complying within 24 hours, or in retaining the child if there were a switch of weeks for that following week. Under either one of those analyses, people have sustained their burden. And therefore, the defendant is bound over to stand trial on this charge.
I'll acknowledge receipt of the information, Your Honor. I'll waive its formal reading, and my client will view this allegation.
Defendant, every way, formal reading, standing mute. Court will enter a not guilty plea. All right.
As a point of clarification, if I may.
Yes.
The court's recitation on the bindover, the court referenced an order of February 17th.
Oh, I meant February 7th.
Okay. Perfect.
If I said 17th, I meant February 7th. All right. Court will indicate the defendant standing mute. Enter a not guilty plea. Pretrial will be set for
October 16th at 1:30 p.m. with Judge Slay.
October 16th, 2023, 1:30 before Slay. Is that
That's a Monday.
That's a Slay Monday.
Your Honor, there is the violation. I don't
Yes.
know if the court wanted to address that.
I do. So that we understand, and I don't how we got here, that the court had ordered Miss Lovely on July 27th that there was to be no posting, commenting on social media regarding this circumstance, or particularly the child, or anything having to do with this. All social media that she had previously posted regarding this case was to be removed, and that the court was very specific that it included anything to do with the child directly or indirectly. That was on July 27th. We returned for a hearing August 17th. The people, I think, filed a motion or a request to an emergency motion on the 9th, I think it was, to revoke her bond. At that time, the court reviewed it. There was a partial hearing on that. Well, there wasn't really a hearing on that date when she came back on the 17th. Based upon what the court saw in the court's previous order, the court did indeed revoke the defendant's bond, remanded her to the Washington County Jail, have subsequently released her from the Washington County Jail, but had set a bond hearing to address the issues in this case, because there was a claim that the subsequent posts were not with reference to the case. And that's where we are.
And I believe that subsequent post was something about a stalker, and then she referenced that, or at least the indication was that was in reference to a landlord or some kind of landlord-tenant dispute.
Correct.
That is my understanding as well.
Where was that landlord-tenant dispute heard? And what was the name of the landlord?
Her name is Emily Knox. The landlord-tenant dispute was at Water Edge Apartments.
Where was the case heard?
There was no landlord-tenant case. We just had a eviction case coming from the property management. But there has been police report filed for her dispute. So previous property manager was not.
So there was no landlord tenant action that was filed?
Not through the courts, there was a police report, police have been called, which that made, and only from the associated with the city. That could be, and we found our eviction. Through part of the edge because of the situation with the old property manager. All right, and that's been taken care of.
It's my understanding that there was an actual court case, but, within
That's what I had.
50 seconds.
Excuse me, the eviction case.
Right. That's Water's Edge Apartments versus Justin Hatchett and all occupants. So
Who's Justin Hatchett?
I believe that's her
That's
significant other fiance.
we're both on the lease. He just was named first.
So how does this relate to that?
There was an incident.
I'm sorry, how does what relate to that?
How does the stalker relate to that case? Because I'm a bit confused only because before she had told me there was a landlord tenant case, then she told me today there isn't a court case, but now I find out that there is a court case, and I'm now trying to relate the language that she was using to that case.
Well, my client indicates, judges, that she was being harassed and stalked by the former property manager. What was the name?
Amberly Knott.
Amberly Knott. And that's the person to whom she was referring when she made that post. There is an email addressed to Ms. or it's to, purporting to be to Amberly. I don't know if that's been tendered, but.
I find it interesting. There was also this issue with the GoFundMe, right? And so the GoFundMe is the GoFundMe. I recognize it's been disabled. It has not been deleted. But in that language, when she's talking about what had happened, she says, still being harassed, stalked, manipulated, and talked about by my ex-husband. So she's referencing that same language that comes in, what was it? In that post from, I think, July 27th, which that apparently happens to coincide with one of our dates here.
Yes.
So it's just too convenient. And I find it too remote to refer to a stalker or a landlord as a stalking, because a landlord is a stationary kind of thing. It's the building. So it's strange, and it seems too remote.
So Judge, the GoFundMe was early July. That was before, I believe, the court's order, is my understanding, when that was created, and it has been disabled. A person can have more than one person harassing them in their lives. So while she may have had, obviously there's a difficult relationship that she has with her ex-husband, that does not mean that she's not also having issues with this landlord property manager. Again, this isn't the owner, this is the person managing the properties who's there in the area, is driving around in a golf cart, is watching her, and has been harassing her. That is what she's reporting. I would ask the court, based on the vagueness of what that post was, to dismiss the bond violation. She's already spent, I believe, a week in jail as a result. And I've admonished her to stay off of social media in its entirety during the pendency of this case. And I don't believe there's any indication that there have been any issues since she was released from custody.
Well, let me just say this. I don't think the defendant believes any court's order. it distressed me, first of all, in coming back, that there was a violation of my order. Right? Then when I'm listening to testimony here, Judge O'Brien issues an order, she didn't want to follow it. She just doesn't believe that people are going to issue orders that may affect her and that she can just decide to do things as she will. I hope her time in jail has sort of bemused her of that idea, especially when it comes to me. I think she's also going to run into a different type of animal well, I don't mean that in a bad way, but a different type of judge when it comes to Judge Slay. And I would almost just dare her to not follow Judge Slay's order to the letter. Because 7 days probably won't be long enough. What I'm going to do is I'm going to find that there's a violation, sentence the defendant to 7 days credit for the 7 she served. I'm also going to issue a new order, or as part of her order going up. And I think it's wise advice, Mr. Overwater. The defendant is not to be on any social media. No use of social media. Ma'am, do you understand me? Thank you.
Thank you.
Otherwise, her bond will continue at this point.
Thank you, Your Honor.
Thank you.
Thank you.